She might want to check her attitude. Can you go tell her to check her attitude?
Sure.
If she doesn't seem to want to listen, then just bring her back in. We'll check it.
Before anything else even happens, notice the temperature in the room. This courtroom doesn't open with pleasantries or small talk. It opens with a correction. When a judge references someone needing to check their attitude, that's not casual language. That's authority setting the tone early. Judges do this intentionally. Courtrooms run on order, efficiency, and respect. And when that balance feels off, the judge resets it immediately. Now shift your focus to what comes next, the search warrant affidavit. This is one of the most important procedural moments in criminal cases, and it often flies under the radar. The officer is sworn in, affirming that everything in the affidavit is true to the best of his knowledge. That oath matters. If any material misstatement is later uncovered, it can blow up the entire case. Evidence gets suppressed. Cases fall apart. So when the judge says they've reviewed and signed off on not just one but multiple petitions, that's a green light for law enforcement. But it's also a paper trail that defense attorneys will absolutely examine later. Viewers, here's the question. When judges approve warrants this quickly, do you see it as efficiency or as a risk that not enough scrutiny is being applied?
Draw near the Honorable Judge Judge Simpson presiding.
You may be seated. And we have Officer Holman who's in. Oh, where is it? Oh, there. Okay, there you are, sir.
Right here, Your Honor. Sorry about that.
All right. No, not a problem. I've reviewed your search warrant. If you could please raise your right hand. Do you solemnly swear or affirm that the information contained in the search warrant and affidavit is true to the best of your knowledge, information, belief?
I do.
All right, great. I've signed off on this. I've also signed off on the other petition, the 2703, and we'll get both of these over to you shortly.
Outstanding. I appreciate it, Your Honor. Thank you.
All right, thank you. This one?
Yeah, that's your. I'll be back.
That was the first block. Okay. Court does call the cases of the people versus Jason Allen.
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Allen, who appears via Zoom from the Wayne County Jail. Sir, can you please state your name for the court?
Jason Allen.
All right, I called all 13 cases.
Thank you, Your Honor. As to the 9 state matters, I was made aware this morning that there are 2, I believe, warrant requests pending that Ms. Londi made me aware of. We do believe.
Oh, to bring it to an even 15.
Pardon me, Your Honor?
Never mind.
Oh, sorry. So we believe a short adjournment would be able to accomplish those both being sworn out. And Ms. Londi and I have been in discussions about a global resolution of all these cases, which I have discussed with Mr. Allen. So I believe a 2 to 3 week adjournment would be able to accomplish all of that as far as all of the state cases.
This is a textbook example of how overloaded criminal dockets actually function. When you hear global resolution, that's legal shorthand for let's clean all of this up in one sweep. Jason Allen isn't facing just one case. He's facing a stack of them, spread across jurisdictions and case numbers. Courts love global resolutions because they save time, reduce hearings, and create finality. Defendants often like them too because multiple charges can collapse into a single negotiated outcome. But here's the strategic angle. Adjournments are leverage. Prosecutors ask for time when they're finalizing warrants or consolidating evidence. Defense attorneys agree when they believe the end result will be cleaner than fighting each case individually. And notice the judge's response: measured, procedural, and approving. No irritation. That tells you the court sees this as reasonable, not stalling. Audience question. If you were a defendant staring at 13 to 15 pending a matters, would you push for a fast resolution or would you gamble by dragging it out and hoping something falls apart?
And then there is a resolution as to the Pittsfield Township matters, Your Honor.
Already?
Yes.
And as to the state cases, that's correct, Your Honor. I neglected to do the waiver. Would the court like me to do that now?
Sure.
Thank you, Your Honor. At this time, people would be come to the honorable court in the office of the defendant, not believe that any conflict exists, make waiver be avoided spelled out.
Likewise, Your Honor, or Natalie Pate on behalf of the Public Defender's Office, Your Honor. Likewise, our office does not believe a conflict exists between our office and this honorable court, but if one were to arise, we would therefore waive such a conflict.
Court also does not believe there's conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. All right, now that we've gotten that out of the way. So on Pittsfield cases, there's a resolution.
Yes, yes, Your Honor. Mr. Siller has extended an offer for the 4 Pittsfield Township misdemeanors to which Mr. Allen would plead no contest to the case ending in 0618. And
0618.
yes, Your Honor, he would plead no contest in that matter in the 3 other cases ending in 0437, ending in 1230, and ending in 1412 would be dismissed.
That is correct, Your Honor. So if you accept that no contest plea, it's 1230, 1412, and 0437.
All right, great. And Mr. Allen, is that what you wish to do?
Yes, Your Honor.
All right, fantastic. You can please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name for the record.
Jason David Allen.
All right. Mr. Allen, it's this court's understanding you're going to plead no contest to the charge of retail fraud under the Pittsfield Township Ordinance. That is a misdemeanor punishable by up to 90 days jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
This is where a lot of people misunderstand what's happening. A no contest plea sounds softer than guilty, but legally, it's almost identical for criminal sentencing. The only real difference is civil liability. By pleading no contest, Jason Allen avoids directly admitting guilt, which can matter if there's a potential civil lawsuit later. Watch how carefully Judge Simpson walks through this. He doesn't rush. He explains it twice. Courts do this to protect the record. If a defendant later claims, "I didn't understand," this transcript becomes the shield. Every right being waived is spoken aloud. Trial rights, witness confrontation, silence, presumption of innocence. This isn't theater. This is insulation against appeals. The judge's tone is calm, but the stakes are real. 90 days jail exposure, fines, court costs, and once you plead, there's no undo button. Viewers, do you think most defendants truly understand what they're giving up here, or are they just trying to get it over with?
Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis or no contest plea.
Potential civil liability, Your Honor.
All right. And sir, to that charge, how do you plead?
No contest, Your Honor.
Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're also giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Not at this time.
Has anybody promised you anything other than what's been stated here today on the record regarding these 4 cases to get you to plead no contest?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 235678. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea. Today is what? Court will accept the defendant's plea of no contest to that charge. Cases ending in 0437, 1230, and 1412. Those matters are dismissed as part of this plea agreement. I'll tell you what I'm going to do. Give me a sentencing date up 6 weeks or more. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be April 9th, 2025, 9 a.m. Part of the reason I'm putting it out there, if there's a resolution on the other matters, we'll try to just combine sentencing.
Understood, Your Honor. Sounds
All
good.
right?
Thank you, Your Honor.
Thank
Yeah,
you.
what's the adjourned date for the state cases?
I didn't give one. You needed 2 or 3 weeks out. What do we have?
Yes, Your Honor.
Thank you. During those matters to March 19th.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Mr. Allen. I'll talk to you again before the 19th.
Okay, thank you. Thank you, Your Honor.
Court does call the case, People versus Gabriel Boyd.
That's a lot of people.
This is a tonal shift, and it's subtle but important. We move from a multi-case plea negotiation into an arraignment, step 1 of the process. Standing mute, waiving formal reading, and entering a not guilty plea is standard defense strategy. It preserves options. Nothing is conceded. The defense immediately requests an adjournment, citing recent appointment and pending discovery. That's not delay for delay's sake. That's constitutional necessity. You cannot prepare a defense without evidence. Judges know this, which is why adjournments at this stage are almost automatic unless there's bad faith. But what makes this moment stand out is the human layer. The defendant is a full-time student. Scheduling conflicts matter. Judges hear these requests constantly, but they don't always accommodate them. Here, Judge Simpson listens, explains court structure, and still offers a workable solution. That balance, firm but reasonable, is a hallmark of experienced bench management.
Good morning, Your Honor. Ida Sparkich on behalf of Ms. Gabrielle Boyd, who's present and standing to my right, Judge.
All right. This is an arraignment and pretrial.
That is correct, Judge. For purposes of arraignment, we waive the formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea.
Thank you, Judge.
And what would we like to do with this case today?
Judge, I was just recently saying I filed my appearance yesterday as well as a discovery request. I will respectfully request an adjournment.
I will adjourn the pretrial in this matter to,
Thank you, Judge. And I just did have a really
hold
quick
on, let
question.
me give you a day.
Okay, sorry. That was going to be my question. Are all the pretrials have to be on a Wednesday? The only reason why I'm asking is my client is a full-time student and the Wednesday, it's a very tough day for her. If at all possible. If not, we'll take the 19th. College of Creative Studies in Detroit. She's a junior, Judge. If not, I can fill out a.
We're gonna have to, they're all on Wednesdays.
Okay, I understand, Judge. Then I would, if at all possible, ask for the 19th. I think that will give me enough.
That way she can arrange things if necessary.
Thank you.
During the matter to March 19th, 2025, 9 a.m. or as your invite indicates. As to bond in this case, alleged BAC.
.114, Your Honor. There was no crash. The defendant has no priors. People would request a soberly.
Judge, if I may say a couple of things.
Yes, go ahead.
Thank you. My client is 22 years old. As the prosecutor stated, there is no prior record whatsoever. She grew up in the city of Ann Arbor. She's gainfully employed. She's also a full-time student at College of Creative Studies. Her parents are both aware of this. I spoke to her father, in fact, before I even spoke to my client. And Dr. Boyd, her father, was not able to make it in today due to the fact that he's working and seeing patients. However, I believe he is on YouTube observing the proceedings, Judge.
Oh, he's watching, okay.
Okay, I would just respectfully, obviously, ask for a personal bond. My client does understand that usually with DUI cases, there is going to be some testing. If you're going to be in post-testing, Judge, she's respectfully asking for a sober link. It's a little bit easier to blow into with her schedule with school and work.
It's a 1-1. How old are you?
114.
114, Judge. My client is 22 years old.
This is advocacy done right. Defense counsel doesn't just recite facts, she builds a narrative. Age, no record, employment, education, family awareness, all of it paints stability. That's exactly what judges look for when deciding bond conditions. And then there's the sober testing request. This is where discretion matters. Instead of imposing SoberLink immediately, Judge Simpson opts for random testing. That's restraint. It recognizes the allegation without over-penalizing before conviction. Audience question: should first-time defendants automatically face strict monitoring, or should courts start lighter and escalate only if necessary?
You grew up in Ann Arbor?
I did, sir.
What high school?
Pioneer High School.
Okay. It's okay.
Okay.
She could have said here on her skyline.
Then you would have
Then I would
imposed
have
grams.
had to do something.
I understand, Judge. I get it. I didn't grow up here, but I get it.
I don't take that personal. I just do. All right. All right. Set the defendant's bond at a $15,000 personal recognizance bond. All other standard conditions, including no assaultive behavior or possession of any weapons. You understand that?
Yes. Yes, Your Honor.
There should be no possession of any alcohol, recreational marijuana, or any illegal drugs. I am not going to, at this time, put her on a sober link. I'm going to leave it
Thank you, Judge.
in terms of that. However, you could be called in for random testing at any point. You understand?
I understand, Your Honor.
All right.
Thank you, Judge. My client does have a medical marijuana card. I know you stated no recreational use. She's not using recreational marijuana, but as far as providing the proof, is that something that I could just provide to the front counter, the copy of her medical marijuana card?
You don't have to provide it to the counter.
Okay.
If she does go in, she needs to make sure.
Provide, got it. Bless you.
Thank
Thank
All
you,
right.
Judge.
Thank you.
Have a wonderful day. Thank you,
Thank
Judge.
you, Your Honor.
Court does call the case, People versus Jonathan Weber.
Conrad Sorum, Blackfield Township.
Morning, Judge. John Shea with and on behalf of Mr. Weber. Your Honor, I haven't had a chance to file a formal appearance yet. Mr. Weber arranged my retention yesterday.
Okay.
We acknowledge receiving a copy of the complaint, waive its reading, and he stands mute at the present time.
Wait from a reading, standing mute. Court will enter a not guilty plea.
Thank you. Purposes of pretrial, Your Honor, I spoke with Mr. Siller for a few minutes prior to the court taking the bench. There's some discovery that we requested, which he will be providing, and we're asking for a 4-week adjournment of the pretrial.
Without objection, I'll adjourn this to March 19, 2025, 9 a.m. As to bond alleged BAC.
Your Honor, it's a blood draw for search warrant .156. There was a crash where the defendant rear-ended another vehicle.
Your Honor, Mr. Weber is 63 years old. He's never been in trouble with the law before. Technically, it was a crash, although in fact it was a very low-speed rear-ending at a red light. Virtually no damage, no insurance claim made. The search warrant was because Mr. Weber initially said he didn't want to consent to a blood draw, then changed his mind, and the police report says, I did a search warrant just out of caution because of the initial hesitation. But he did in fact ultimately consent after reconsidering his initial refusal. He is retired from the practice of law and is not constantly employed, does some things, and is taking care of some health issues as well.
What I'll do is I'll set the defendant's bond at a $15,000 personal recognizance bond. All other standard conditions, including no assaultive behavior or possession of any weapons. There should be no use of alcohol, recreational marijuana, or any illegal drugs. I am going to order, because of even though it being a minor crash, the accident, as well as the levels on his testing, I will order the defendant report to community corrections for placement on a sober link testing device.
Thank you, Judge.
Thank you.
Okay.
See you in 4 weeks. Thank you, Your Honor.
Yes, sir. I did give that to you. I did. Okay. Court calls the case, People versus Angela Walker.
Shalani for the people.
And here's where tone hardens. When a judge references prior warnings, that's never casual. Compliance history matters more than promises. Missed tests, even technical ones, erode trust fast. Judge Simpson explicitly acknowledges he could remand her. He chooses not to. But the trade-off is harsher monitoring, scram tether. This is escalation. Courts escalate when they feel manipulated or ignored. Audience question: Was the judge fair here or too lenient given the missed test?
Carolyn Foster Tucker on behalf of Angela Walker. Angela Walker.
Thank you. All right, where are we?
Your Honor, Ms. Londy and I have spoken. I believe we're close to a resolution, but we're just asking for a little bit more time. If we could adjourn it to the March 5th date.
All right. How long an adjournment did you need?
March 5th, Your Honor, if that's okay.
Adjourn the matter to March 5th, 2025, 9 a.m. or as your invite indicates. Ms. Walker, you remember our conversation on December 18th?
Yeah,
What did they tell you?
don't mess up.
What?
Don't mess up on my trick. Is that what it's called?
Your
My blow.
sober link?
Yes.
What did I tell you? No more missed tests.
Yeah.
December 24th, what happened?
It didn't charge. And so it had no charge on it and I had to wait for it to charge to blow in it.
And you missed the test block.
Yeah, I blew in it anyways, even though I knew it was going to be a mess.
Well, typically when I give somebody that ammunition, that I would remand them. I'm not going to do that in this case. However, you will be switched to a scram tether, then we don't have to worry about the test. I need an order. I didn't get a chance. So you'll need to report over to community corrections. Might as well do that while you're here. Turn in your you got to turn in your sober link and then get a scram. All right. Thank you.
Thank you, Your Honor.
She might want to check her attitude.
This is courtroom authority on full display. Judges don't comment on attitude unless it's visible, disruptive, or disrespectful. When Judge Simpson flags it, he's not venting. He's preserving decorum. Courtrooms are structured environments. Emotional reactions are human, but unchecked defiance undermines proceedings. What makes this moment compelling is the judge's self-awareness. He openly states he tried to do something nice. That's a reminder. Leniency is discretionary, not guaranteed. When defendants respond poorly to leniency, courts recalibrate quickly. Viewers, consider this. How much does demeanor influence outcomes? Two defendants can commit identical violations, but the one who shows accountability often receives dramatically different treatment.
Can you go tell her to check her attitude? If she doesn't seem to want to listen, then just bring her back in and we'll check it. Pyranny, see, I tried to do something nice. Middle ground. You're not buying it? No?
I thought it was
Wow.
very kind of you, Judge.
You're very kind of you, Judge, because I have clients coming up. All right. It took you a while to get there, but okay. Court calls the case, People versus Stephanie Hirsch.
However, on behalf of Ms. Hirsch, who's approaching the podium as we speak.
I gave her a warning.
So, please state your name for the record.
Stephanie Hirsch.
Thank you. All right, what are we doing?
Yeah, I did extend an offer to defendant. It's not, the terms of that offer have not been completely completed. So I believe defense counsel is going to request an adjournment to either fulfill the original terms of the offer or a modification that I made today that she can do to complete the last bit of it.
Okay.
Yes, the offer was to complete 10 hours of community service for dismissal. Ms. Hirsch is about a half hour short. So we're asking for an adjournment. I believe March 5th was the date that the court.
She didn't count or just ran out of time?
Just ran out of time.
Oh, okay. Just kidding. All right. March 5th, she'll be able to get that by that point. All right. I'll adjourn the matter March 5th, 2025. And where as your invite indicates. All right. Thank you. So how was she? She was okay? Was she? Was she? What'd she think when she saw you? Did she? Oh. Court calls the case of the Newell versus Dave Loss.
Ashley, want to people?
It's an arraignment. Take hands out of your pockets. What's your name?
Dave Loss.
All right, sir, you are before the court on a complaint that alleges that on or about November 2nd, 2024, the location of US 23 near East Michigan Avenue in Pittsfield Township, Washtenaw County, state of Michigan, count one alleges that you operated a motor vehicle with a high BAC. Do you understand the nature of that charge, sir?
Yes, sir.
That's a misdemeanor punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
Count two alleges that you operated without a license on your person, commonly known as no ops on person. You understand the nature of that charge?
Yes, sir.
This is procedural, but significant. 2 charges, 2 separate exposures. Judges meticulously explain penalties here not for drama, but for appellate protection. If a defendant later claims ignorance, this transcript shuts that door. Notice the defendant immediately requests a public defender. That triggers a different pace. Pre-trial, adjournment, not guilty pleas entered automatically. This is the system working as designed. But the BAC, 225, is alarming. That number alone influences everything that follows. High BAC cases rarely get leniency, even for first offenses. Judges view them as public safety risks, not isolated mistakes. Audience question, should BAC levels alone dictate bond severity, or should context matter more?
That is a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. Do you understand that?
Yes, sir.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes, please.
Public defender Fish.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Bloss.
Yes, ma'am.
We would waive any further reading, stand mute to the charges and ask for another pretrial date.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all charges. Pretrial in this matter will be adjourned March 5th, 2025, 9 a.m. Pledge BAC in this matter.
0.225, Your Honor. There was a single vehicle crash. The defendant that I can see has no priors. People are requesting to bring.
Response to bond.
Your Honor, we would ask for a personal bond. If I may confer with my client for just one moment.
You may.
I can do this over link. No, I don't. No. Oh.
Your Honor, I explained the difference between a Scram and a SoberLink. He is asking for a SoberLink device.
I'll set his bond at a $25,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of weapons. You understand that, sir?
Yes, sir.
There's to be no use of any alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes, sir.
I am further going to indicate that the defendant is over to the Department of Community Corrections. I will place him at this time on a SoberLink device with the understanding that if he misses any of those tests, what is going to happen is he's going to be remanded. I may not use that intermediate sanction.
This is one of the clearest warnings you'll ever hear in court. No ambiguity, no soft language. Miss a test? Go to jail. Judges sometimes prefer clarity over compassion, especially in high-risk cases. SoberLink isn't optional here. It's conditional freedom. The judge explicitly states he won't use intermediate sanctions. That means no second chances. That's rare, but intentional. High BAC plus a crash equals 0 tolerance. Audience engagement. Do you think this level of strictness prevents future harm, or does it set defendants up for failure?
Given the level of alcohol.
Thank you.
Court calls the case, People versus Kyle Burmeister.
Absolutely. For the people.
Hello,
How's it going?
your name?
Kyle Smith Blue.
Pardon?
Kyle Smith Blue. That's not it.
You're not Kyle Burmeister?
No, I heard like commotion. I'm sorry. I guess not.
Okay, why? You want to take his charge instead of yours or what? You don't know, do you? Kyle Burmeister? No response. I don't know why we. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $7,500. Give a 10% privilege on that. That warrant will issue immediately. Court calls the case of People versus Billy Cobb Gilly.
People.
Sir,
Good morning.
what's your name?
My name is Billy Cobb Gully.
All right. Sir, you are before the court on a misdemeanor complaint that alleges that on or about November 29, 2024, at the location of US 23 near Washtenaw, Pittsfield Township, Washtenaw County, State of Michigan, that you did operate a motor vehicle with a high BAC. You understand that?
Correct.
And so you understand what you're charged with?
Yes.
All right. That's a misdemeanor punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes.
All right. First question I have for you, sir, is do you wish to be represented by a public defender?
Yes.
It's a public defender case.
This is Public Defender Natalie Pate on behalf of Mr. Cobb Gilly. We would waive any further reading, stand mute, and ask for another pretrial date, please.
And then having waived formal reading, standing mute, will enter a not guilty plea. Discharge. Pretrial in this matter will be adjourned March 5th, 2025, 9 a.m. or as your invite indicates. As to bond in this case, HVAC.
Your Honor, this is a case that involves alcohol and marijuana, so the alleged BAC was 0.188. They were also detected in the defendant's blood 10 nanograms of delta minus THC. People are requesting SoberLink or scram tether, as well as at least intermediate supervision at community corrections and a no marijuana condition.
Ms. Pate, you may want to.
Oh, sorry, Your Honor.
Yeah,
I've been
it
bad
came up.
at
It was red.
I've been bad at that today. Your Honor, we would respectfully request the court consider a SoberLink breathalyzer, but we understand if the court would order a scram.
Well, I don't know. Right. All right. So 188. There was no accident, you said?
There was no crash, and I don't show that the defendant has any prior history of OWI offenses.
All right. How old are you, sir?
30.
Do you have a medical marijuana card or no?
No.
I've adjourned it out to March 5th. I'm going to order standard conditions, including no assaultive behavior or possession of any weapons. There's to be no possession of any alcohol, recreational marijuana, or any illegal drugs. I'm going to order it also that you're to report to community corrections. I'll place you on a SoberLink testing device at this time. My minimum testing on that. I'm also going to order at this time drug testing 2 times per week. Since he doesn't have a card, that level is going to have to go down. He needs to understand that we can get the levels on it. So if he's using, we're going to know. All right. There's a $20,000 personal regardless.
Thank you, Your Honor.
This bond reflects balance. No cash up front, but heavy oversight. The court sends a clear message. Freedom continues only if compliance does. Drug testing twice a week isn't symbolic. It's invasive. It disrupts schedules. That's intentional. Courts want accountability to be felt, not ignored. Viewers, does supervision like this deter future offenses or merely manage risk temporarily?
Your name?
Ashton Ebler.
Sir, you are before the court. Unregistered vehicle, it's a 95. Do you have the penalties, Mr. Solero, on driving an unregistered vehicle?
Your Honor, that is 90 days and or $100.
Is it 91? Okay.
90.
All right. Sir, you are before the court on a misdemeanor citation that alleges that on or about January 18, 2025, at the location of US 23 and Michigan Avenue in Pittsfield Township, that you drove an unregistered vehicle. Do you understand the nature of that charge?
Yes, sir.
That's a misdemeanor punishable by up to 90 days and a $100 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. First question I have for you is, do you want to be represented by an attorney on this?
Yeah, I'd like to speak to somebody.
Pardon?
Yeah, I would like to.
All right. This is a public defender case.
Good morning. This is Public Defender Lauren Carney on behalf of Mr. Ebler, and we are asking for another pretrial date, Your Honor. Waive any further reading charges.
Defendant every way form of reading standing mute, or will enter an act. Pretrial in this matter, I'll adjourn this out to March 19th, 2025, 9 a.m. Set his bond at a $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of any weapons. You understand that, sir?
Yes, Your Honor.
I'll order no alcohol, recreational marijuana, or any illegal drugs. All right, you're all set. We'll see you in about a month.
Thank you.
Thank you.
Court does call the case People versus El Haji Faye.
After money and people.
El Haji Faye. No response. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. Well, actually, no, this first show, isn't it? I'll order a show cause. Court calls case People versus, is it Emily Fox?
After money for the people.
Emily Fox. No response. What's the alleged VAC in this matter?
Yeah, this is a drug case.
Oh,
So
it's
the
drugs.
alleged drugs that allegedly were found in the defendant's blood include fentanyl, methamphetamine, and amphetamines. There's a 2-vehicle crash.
Got it. I'm going to, for those reasons, in public safety, skip the show cause portion. I'll show bench warrant for defendant's failure to appear. Bond is set in the amount of $15,000. I'll give a 10% privilege at this time, but that warrant will issue immediately. Court calls the case People versus Michael Hale.
After money for the people.
Michael Hale. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in amount of $5,000, 10%.
At this point, the pattern is unmistakable. Failure to appear once might be forgiven. Failure to appear after a prior warrant? That's when judicial patience ends. Courts view repeat non-appearances as willful disregard, not confusion. And notice the judge's efficiency. No lecture, no commentary, just action. This is important for viewers to understand. The courtroom is not reactive, it's procedural. When someone doesn't show up, the process moves forward without them. The court's responsibility isn't to chase defendants, it's to maintain order and protect the integrity of the system. Audience question: do repeated failures to appear signal irresponsibility, fear, or something deeper going on in a defendant's life?
That warrant will issue immediately, there having been a previous warrant. Court calls case People versus Michael, is it Clustra or Clustra?
After money for the people.
Good morning, Your Honor.
Good morning, your name?
Michael Scott Klustra.
All right. Sir, you are before the court The original one. On a misdemeanor complaint that alleges that on or about October 23rd, 2024, at the location of Hogback Road near Clark Road, Pittsfield Township, Washington County, State of Michigan, that you did operate a motor vehicle while intoxicated. You understand the nature of that charge, sir?
Yes, sir.
All right. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. Court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney, sir?
I do not have an attorney today, but I am going to get one.
You're going to hire your own?
Yes, sir.
Do you know when you're going to be able to get that accomplished?
Hopefully today when I get home.
And what I will do is, at this point, I will indicate that you're not asking for any further reading of the complaint in this case, understanding the nature of the charges and the maximum penalties. I'm going to indicate that you're standing mute to the charges. I'll enter not guilty plea at this time on your behalf. You understand all of that, sir?
Yes, sir.
Alleged BAC in this matter.
Your Honor, a drug OWI, 10 nanograms of delta-9 THC, a single vehicle crash. The defendant has no prior OWI history that I can see.
This exchange shows how quickly credibility can slip. The defendant initially implies past legality as justification. I used to have a card. Courts don't operate on used to. They operate on at the time. Without a valid medical marijuana card, THC becomes a violation, not an explanation. Judge Simpson's response is methodical. High bond, no substances, mandatory drug testing. This isn't moral judgment, it's risk assessment. A crash plus THC equals elevated supervision. Audience engagement. Should DUI laws adapt further as marijuana legalization expands, or should responsibility standards remain strict regardless of legality?
Do you have a medical marijuana card, sir?
I used to before it was legalized here in the state of Michigan.
So the answer to that is no.
Yes, sir. No, I do not have one at this time. Sorry.
I'll set his bond at a $15,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior. There is to be no possession of any weapons. Also, there's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. I will order that you are to report over to community corrections for drug testing. At this point, I'm going to order 2 times per week drug testing. I signed that order. You might want to stop by there right now. You have to appear there within 24 hours. You might want to stop before you leave the campus here. I will adjourn this matter to March 5th, 2025, 9 a.m. or as your invite indicates.
Sir, may I ask if I could have that date changed to the 19th or 26th of March?
Why?
My wife needs to drive me because I have epilepsy. So since that crash, I can't drive for 6 months.
Okay. All right. She's here with you.
Yes.
All right. Will the 19th, I understand that. Will the 19th work for you to get him here?
I would like to have this work. I'd like to take it this if we can.
Do what?
I'll do it.
The 5th? Oh, the 5th would work better.
You wrote down, okay. I'm sorry. She wrote down 2 dates. So
Who wrote down 2 dates?
my wife wrote down 2 dates.
And you read the wrong one.
No, she wrote,
No, you read the wrong one. She said the 5th would work. You should have asked. You
she
know
wrote
what?
the 19th.
He was up here trying to make his own decision.
Never.
He should have turned around, asked, and said, "Dear, what day should I choose?" Said I had to get involved in that. You want the 5th, ma'am? Okay.
This moment stands out because it humanizes the courtroom without undermining authority. Judge Simpson injects humor, but the lesson is real. Listen, communicate, and don't improvise in court. Judges often use humor as a teaching tool. It diffuses tension while reinforcing responsibility. Everyone in the room understands what just happened. The defendant tried to manage logistics solo and stumbled. The judge steps in, resets the situation, and moves on. No penalty, but the message lands. Audience question: does humor from the bench make court more effective, or does it risk diminishing seriousness?
See, he just listened, right? He just listened. It wouldn't have been a problem. The fifth. All right. No, don't try to, you know what? Don't try to redeem, do not try to redeem yourself. All of these people know that you were wrong.
Yes, sir.
All right, thank you. Take care. Have a good day, folks. Court calls the case, People versus Jason Pope.
Special Lonnie for the people. I'm sorry, a Russian interpreter.
Yes, you may.
Good morning, Ms. Boyd. Can you please turn on your camera, unmute, and raise your right hand to be sworn? Ms. Boyd, can you please turn on your camera, unmute, and raise your right hand to be sworn?
Oh, there she goes. Oh, there she is.
Can you see me and hear me? Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Russian and from Russian into English, in the manner now before the court to help you God? I do. Thank you.
All right. Good morning, Madam Interpreter.
Good morning. May I first ask you to give me an opportunity to introduce myself to the defendant in Russian and check for understanding?
Yes, you may.
Thank you, Your Honor. Здравствуйте, Михаил. Меня зовут Белла Анжель Хойт. Я буду вашим переводчиком и буду переводить все, что вы говорите. Также прошу вас говорить более короткими предложениями и чаще делать паузы для точности и полноты перевода. Заранее вам благодарна. Вы меня слышите и понимаете?
Да, я вас услышал и все понял. Спасибо.
Минутку. So this is the interpreter. The interpreter introduced himself and checked for understanding. And he responded, yes, I can hear and understand you. And I understood.
All right, thank you. Court does call the case of the People versus Mikhail Panaseka.
Сейчас вызывает суд дела штат против Михаила Панасенко.
Ashley Lundy for the people.
Также, this is the interpreter. Your Honor, I could not hear your name clearly.
It's Ashley Lundy for the people.
Эшли Ланди будет представлять интересы обвинения.
Ronald Bruce on behalf of Mr. Panasenkov.
Рональд Брус будет представлять интересы господина Панасенкова.
And what are we doing on this case today?
Сегодня что мы будем по данному делу делать?
There is an offer available.
Есть тут предложение.
To plead to case 2410886.
Чтобы признать себя виновным по делу 241-0886.
And 2410888.
И также по делу номер дела 241-0888.
And dismiss 2410887.
И также закрыть дело 24, номер дела 241-0887.
And counsel, what is your client's intention?
Какое намерение у вашего клиента?
Judge, it's our intention to go forward with that plea offer.
Мы намереваемся принять условия данной договоренности о вине.
Sir, can you please raise your right hand?
Пожалуйста, поднимите свою правую руку.
Do Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Клянетесь говорить только правду, чистую правду и ничего, кроме правды. Бог вам в помощь. Клянетесь ли вы?
Клянусь.
I swear.
State your name for the record, sir.
Для протокола полностью скажите ваше имя.
Михаил Панасенков.
Михаил Панасенков.
You may put your hand down.
Можно опустить руку.
Sir, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor charges. Is that correct?
Насколько суд понимает, что вы признаете свою вину по 2 пунктам, 2 правонарушениям, верно?
На этот вопрос ответит мой адвокат.
My attorney will answer this question.
No, you need to answer the question. Is it your understanding that you are pleading guilty to 2 misdemeanor charges?
Вам нужно ответить на ваш вопрос, на этот вопрос. Понимаете ли вы, что вы признаете себя виновным по 2 правонарушениям?
Да, понимаю.
Yes, I understand.
First charge is the charge of
Первое правонарушение.
violation of the motor carrier fuel tax. You
Это
understand? Oh, go ahead.
нарушение, связанное с тем, что это было связано с налогом на транспортные средства. Вам это понятно?
Да, понятно, я согласен.
Yes, I understand. I agree.
That's a misdemeanor punishable by up to 90 days and a $500 fine plus court costs. You understand that?
Правонарушение наказывается тюремным заключением на срок до 90 дней и штрафом на сумму до $50 плюс судебные издержки. Вам понятно?
Да, понятно.
Yes, I understand.
The other charge is a charge of improper registration fees paid.
Второе обвинение состоит в том, что неверно были оплачены регистрационные.
That's a misdemeanor punishable by up to 90 days. Is that a 100 or 5?
Регистрационные документы, это также наказывается сроком до 90 дней тюремного заключения и до $50 штрафа плюс судебные издержки.
Понятно.
Pulling it up now.
Она говорит, минутку.
I believe it's $100, Your Honor.
90 days, $100 fine plus court costs. Do you understand that, sir?
Она говорит, я думаю, что там $100 штраф. Судья говорит 90 дней, до 90 дней заключения и также штраф на сумму до $100 плюс судебные издержки. Вам понятно?
Понятно.
I understand.
Sir, to the charge of motor carrier fuel tax violations, how do you plead? Guilty or not guilty?
По обвинению в том, что нарушили налоги, связанные с транспортным средством, как вы себя признаете, виновным или невиновным?
По налогам?
Tax. In terms of tax?
Yes. To the charge of motor carrier fuel tax violations, how do you plead? Not guilty or guilty?
Относительно нарушения топливного налога на транспортные средства, как вы заявляете о вине, виновный или невиновный?
Виновен.
Guilty.
To the charge of improper registration fees paid, how do you plead? Not guilty or guilty?
Относительно обвинения, что неверно были оплачены регистрационные взносы. Как вы заявляете о вине? Невиновен или виновен?
Виновен.
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
И вы понимаете, что если вы признаете себя виновным, у вас совершенно не будет судебного процесса. Вам понятно?
Нет, непонятно.
No, I don't understand.
Could you repeat that? He doesn't understand.
This is the most fragile moment of the entire docket. A defendant openly states confusion mid-plea. Courts cannot proceed until clarity is restored. Judge Simpson immediately pauses, clarifies who is being addressed, and resets the question through the interpreter. This is justice slowing down when it must. Rushing here would risk overturning the plea entirely. The judge's patience is not optional, it's required. Audience engagement should please ever proceed if a defendant shows repeated confusion, even with interpretation.
Вы можете повторить, что он не понимает минутку. And this is the interpreter, Your Honor. Whom are you addressing?
I was addressing you. I'm sorry, Madam Interpreter. What was his response?
Your interpreter just interpreted what he said. If you want, you can ask the question again.
Do you understand that you will not have a trial of any kind?
Вам понятно, что у вас не будет совершенно судебного процесса?
Да, это понятно.
Yes, I understand.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance.
И из-за этого вы отказываетесь от некоторых прав, вы отказываетесь, чтобы у вас на судебном процессе были вызваны свидетели, чтобы суд на судебном процессе.
You're also giving up your right to see, hear, and question all witnesses against you at trial.
Вы также отказываетесь от права видеть, слушать, задавать вопросы всем свидетелям, которые будут против вас на судебном процессе.
You're also giving up your right to be a witness for yourself or to remain silent and not have that silence used against you.
Также отказываетесь от права свидетельствовать от своего имени или же хранить молчание, и также, чтобы ваше молчание не использовалось против вас. Также отказываетесь от этого права.
Верно.
And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt.
Вы также отказываетесь от своего права презумпции невиновности, пока не докажет вашу виновность вне всяких сомнений.
Do you understand that you're giving up all of those rights, sir?
This is the legal firewall. Every right waived is spoken, translated, and acknowledged. Trials, witnesses, silence, presumption of innocence, appeal rights. This protects the conviction more than it pressures the defendant. Courts don't assume understanding. They document it. This transcript becomes the record that withstands future challenges. Audience question: do you think defendants truly grasp the weight of these waivers in real time?
Вам понятно, что вы отказываетесь от всех этих прав?
Да, мне понятно.
Yes, I understand.
You understand you're giving up your right to appeal of right.
И вы также понимаете, что вы отказываетесь от своего права на апелляцию?
Да.
I do.
Are you on probation or parole?
У вас сейчас есть испытательный срок или досрочное судебно-тюремное освобождение? По-английски это называется probation или parole.
Нет.
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
Кто-нибудь что-то вас обещал, кроме того, что мы сегодня уже дали это при записи на протокол, для того, чтобы вы признали себя виновным по данным обвинениям?
Нет, никто ничего не обещал.
No, no one has promised anything.
Has anybody threatened you in any way to get you to plead to these charges?
Кто-нибудь угрожал ли вам для того, чтобы вы признали себя виновным по данным?
Нет, Ваша честь.
No, no one.
You're doing this voluntarily and of your own free will?
Вы делаете добровольно это?
Да.
Yes.
And you're also doing it because you believe that you're guilty of these charges?
Также это делаете, потому что вы считаете виновным себя по этим пунктам?
Да.
I do.
On June 27th, 2024,
27 июня 2024
on US 23,
по трассе, по-английски называется 23,
my apologies, at the location of US 12 in Pittsfield Township, Washtenaw County, state of Michigan.
прошу прощения, это было по трассе US-12 в городке Питтсфилд в штате Мичиган.
Did you operate a commercial vehicle?
Были ли вы за рулем коммерческого автомобиля?
Да, был.
Yes, I did.
Do you admit that you failed to register under the Unified Carrier Registration Act?
Признаете ли вы, что вы не зарегистрировали по акту, который называется Unified Carrier Registration Act? То есть акт всеобщей регистрации.
Да.
Yes.
Do you also admit on that same date and at that same location that any registration fees that you had paid were improper, in that there were not enough or none at all?
И также признаете ли вы, что в тот же самый день, в том же самом месте все регистрационные взносы, которые вы заплатили, были неверными, или же их было недостаточно, или же они совсем не были внесены?
Да.
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas?
Yes, Judge.
Адвокат, следовал ли я всем судебным правилам? Можно ли признать заявление о вине данного обвиняемого? Адвокат говорит да.
Yes, Judge.
Да, судья.
Yes, Your Honor.
Да, Ваша честь.
Court will accept the defendant's pleas of guilty to these two charges. The other charge is dismissed.
Суд тогда признает вину обвиняемого по этим пунктам, а последний пункт снимается.
Is there anything you'd like to say before I impose fines and costs?
No, Judge, would ask that.
Я сообщу о штрафах и судебных издержках. А тот говорит нет, ничего, судья.
In each case, I will suspend any time in jail to 90 days.
И также по каждому делу я не буду давать 90 дней тюремного заключения.
Thank you, Your Honor.
And in each case, $250 fines and costs.
Suspended jail is mercy with conditions. The judge could impose incarceration, but chooses fines instead. This reflects proportionality. Regulatory offenses, no violence. Compliance-focused sentencing. But suspension isn't dismissal. Any violation resurrects jail exposure. That's the leverage. Audience engagement. Is suspended jail an effective deterrent or just a warning label?
И по каждому пункту $250 штрафов и судебных издержек. And this is the interpreter, Your Honor. I did not hear you clearly. About 90 days in jail. Would you please?
That is suspended. He doesn't have to do any jail time.
Вам не требуется отбывать тюремное заключение.
God bless you, Your Honor.
$250 fines and court costs.
$250 штрафы и судебные издержки.
Да, okay.
So that's a total of $500. When can you get that paid?
А общая сумма будет составлять $500. Когда вы можете это заплатить?
Я думаю, в течение 2 недель я это сделаю.
I think I will be able to do it within.
When?
Этого
I'm sorry.
достаточно?
One moment, your interpreter didn't hear him. Простите, что вы сказали последнее?
Это достаточно время?
Would that be enough?
I'm sorry, he's got a total of $500 he has to pay. When can he pay that?
Прошу прощения, вам всего надо заплатить $500. Когда вы можете заплатить?
В течение 2 недель устроит?
Would it be possible to do within 2 weeks?
Pay it by March 7th.
До 7 марта заплатить.
Deadlines matter. Courts prefer clear, achievable timelines. 2 weeks, specific date, no ambiguity. Payment compliance is often the final test of accountability. Miss it, and consequences follow. This is where cases quietly succeed or fail. Not in the courtroom, but afterward. Audience question. Should courts offer more flexible payment plans, or does strict scheduling reinforce responsibility?
Okay, it's very good. Awesome. Okay.
Thank you.
Благодарю вас.
Thank you, Anna.
This docket tells a clear story. Judge Simpson runs a courtroom grounded in structure, proportionality, and escalation. First-time defendants receive measured supervision. Repeat violations trigger stricter monitoring. Missed tests and failures to appear erase goodwill quickly. We saw global resolutions, no contest pleas, interpreter-protected guilty pleas, and immediate warrants, all tools courts use to balance efficiency with fairness. Above all, credibility mattered. Defendants who communicated clearly and complied received flexibility. Those who didn't faced swift consequences. This is how modern misdemeanor courts function, not with grand speeches, but with consistency, documentation, and consequences that scale with behavior. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.